Maybe Lordship.
Yes.
Lordship, I beg to mention item 7. I'm for the paper response number 5. Item 7, Lordship.
Item 7.
Item 7, Lordship. I'm yet to file my affidavit, Lordship. Item 7. I'm for the paper response number 5. Kindly grant me 3 weeks' time, Lordship.
Counsel for the petitioner is present.
Yes, Your Lordship.
Okay. Miss
Kim Piana.
Kim Pianu, Line Counsel for the petitioner is present. Stop. Mr. Posega Forte, Line Counsel for the respondent number
5, Lordship.
5. Prays for further 3 weeks' time to file affidavit in opposition. Prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks.
May it please Your Lordship, I beg to mention hearing item number 23, Your Lordship. Since my senior is at this post, can you give us a week time, Your Lordship?
You are for the petitioner.
No, respondent number 3.
You are for respondent number 3.
Yes.
Okay. No objection. Okay. Mr. Moazemi, Line Counsel for the petitioner is present. Ms. Kim Penyu, Line Counsel submitted her senior is indisposed, therefore pray for adjournment, to which the Line Counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after
A week.
a week. Okay.
Your Lordship, yeah, please, I beg to mention item number 8. I'm for respondent number 1 to 5. I've received a corrected copy, and I'm waiting for the instruction, Your Honor. I pray for 4 weeks' time. Respond number 1 to 5.
Okay. Mr.
Alam mo pang aw.
Yes, Mr.
M. Solo, Your Lordship.
So, Line Counsel, M. Solo, Line Counsel for the petitioner is present. Miss Alem Wapang, Mr. Alem Wapang Ao, Line Counsel for the respondent number 1 to 5.
Yes, Your Honor.
Submits that he has received a copy of
The petition, the corrected petition.
the corrected petition.
Yes.
When did you receive?
I received on the 26th.
Okay, received. And he need to go through the same to response for which he required some time. He is prayed for, comma, list
4
this
weeks.
matter after 4 weeks.
Yes.
Okay.
Much.
Thank you, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 12 on behalf of IME, Lordship. If 3 weeks' time may be granted to me to file my affidavit in opposition, Lordship. Item 12.
12, the petitioner is present. Whether the counsel for the petitioner is present, having informed.
Yes, Lord. Yes, Lordship.
Okay,
No objection, Lordship.
Mr.
Nakulayam ko niya.
Okay. Noklang Konyak, Line Counsel for the petitioner is present. Ms. Cheng, appearing on behalf of Ms. IME, Line Government Advocate. Praise for father. How much time you said?
3 weeks, Lordship.
Father, 3 weeks time to file affidavit in opposition and to obtain instruction and to
Yes, Lordship.
file
3
affidavit in
obtaining
opposition.
instructions.
The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship, I also beg to mention item 13 on behalf of Vijimomi, Lordship. I sent for vetting, so kindly grant me a week's time, Lordship. Item 13.
Oh, Mr. Moji.
Lordship, here, Lordship, in the last occasion also, last chance was given, Lordship. Now, Lordship, the issue involved disqualification of dissolution of the village council, and it's a 10-year post.
Okay.
So the tenure is getting over next year, March.
Lordship, I have sent for vetting, Lordship, if a week's time may be granted, Lordship. Just
The
a week.
vetting was sent before the summer break.
Lordship.
Hmm.
So, Lordship, I'll make
If-
an
if
endeavor
it
to
is a
inform the.
tenure-
Lordship, let the matter be listed on Monday, Lordship. There's an urgency involved.
Monday. Or
Monday.
Monday, Lordship.
no date file affidavit,
Lordship, on Tuesday, 22.
Tuesday.
Lordship. No further adjournment, Lordship.
Lordship.
Okay. Mr. Jimomi. Land Council for Land Government Advocate. Prays for further 1 week time to file affidavit in opposition on behalf of the state respondent.
Lordship.
Okay, Mr. Moses Land Council for the petitioner is present. Okay, as prayed, comma, the matter is fixed on, let the matter be listed on
22nd,
22nd.
Lordship.
7.
It is made clear that no further adjournment shall be granted to this,
Lordship.
to the state. Okay.
Obliged.
Oblige, Lordship.
Please, Lordship.
Mm.
Lordship, may be pleased to mention hearing item number 20 and 21.
20,
And 21. Your Lordship, if this matter can come up on 22nd, Tuesday, Your Lordship, for hearing.
No objection, Your Lordship.
no objection, okay. Miss Libika,
Yes, Your Lordship.
Land Government Advocate, appearing on behalf of the state respondent, pray for listing this matter on
Tuesday, Your Lordship, 22nd.
22nd, to which the Land Council for the petitioner has no objection. Okay. Accordingly, list the matter on Tuesday.
Much obliged.
That's fine. May I please, Your Lordship? I beg to mention item number 19.
Item
19,
19.
yes. We're yet to file our affidavit in reply, so kindly grant us 2 weeks' time to file the same.
I'm for 2 and 3, Lordship.
Okay. Miss
Abdi,
Land Council for the
Petitioner.
applicant.
yes, yes.
This is IA, applicant. Prays for how much time you said?
2 weeks.
Further 2 weeks. Time to file affidavit in reply to the affidavit so filed by the respondent. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
My appearance may kindly be shown, Lordship.
Okay, not objected by Mr. Mozamir, Land Council appearing on behalf of the respondent number
2 and 3, Lordship.
2 and 3. Okay.
Oblige, Lordship.
May I please, Lordship? Lordship, I beg to mention hearing item number 24. Lordship, I have taken the consent of the petitioner. Can this matter come up on 28?
28.
Yes, Lordship, we have difficulty to take up today.
Okay. Mr.
Ali Wolscombe, Lordship, I'm for the respond number 2 and 3.
Okay, Land Council for the respondent number 2 and 3. Requested for listing this matter on 28
28, Lordship.
July, 28/7/2025, to which Ms. Luzino, Land Council for the petitioner has no objection. Accordingly, the prayer is allowed. List it accordingly on 28/7/2025. Okay.
May this, Your Lordship. Lordship, I beg to mention item 14 on behalf of Interim additional AG, Lordship. If 2 weeks' time may be granted to me, Lordship. Item 14
For what?
to,
2 weeks time for affidavit,
yes, Lordship.
filing affidavit. No objection.
Lordship.
Okay. Ms. Chang, Land Council for the state Land Government Advocate, appearing on behalf of the state respondent, prays for further
2 weeks, Lordship.
2 weeks time to file affidavit in opposition. This is IA is for what? It's objection only. IA is for what?
Lordship, the IA is for stay, Lordship. Stay has already been granted, Your Lordship. And they were
Okay,
asked to seek
okay.
instructions on that, Your Lordship.
Okay. To which the Land Council for the applicant has no objection. Accordingly, the prayer is allowed. List this matter after 2 weeks.
Lordship. Obliged, Lordship.
Interim passed in the IA as well as in the petition may be extended, your lordship.
Sir, the interim order passed in IA Civil 81/2025 as well as in WPC number 72/2025 shall continue till the next date of listing. Okay.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention hearing item 17 and 18. My senior is indisposed. Kindly fix the matter on 4th of August.
You're for the respondent.
Yes,
Okay. When do you want, you say?
4th of August.
4th August. No,
I wanted an earlier date, however, they have expressed their difficulties, so
earlier means when? Propose the date
Lordship,
or 4th of August.
Lordship,
So we'll grant 4 weeks time. That will be last part of. Okay,
Lordship,
4th of August,
5th August
sorry,
is okay.
sorry. Sorry, when do you want then?
Lordship, 4th August is okay. Lordship.
Okay. Miss
Menoshino.
submits that her senior, Mr. L. Iral, who
Yes.
Iralo is indisposed, therefore pray for adjournment and to be listed it on 4/8/2025, to which Ms. Lozino, line of counsel for the petitioner, has no objection. Accordingly, list the matter on 4/8/2025. Okay.
Lordship. May I please, Your Lordship?
Hmm.
I'd like to mention item number 9, 10, and 11. I've received the affidavit in opposition, so kindly grant me 3 weeks' time to file my reply.
Okay. Miss
Asarutsa.
Asarutsa, line of counsel for the petitioner, submits that she has received a copy of the affidavit in opposition in the above writ petitions and 6 time and wants to file affidavit in reply, for which she seek for almost
3 weeks.
3 weeks time, to which the line of counsel for the state respondent, Ms. Chang, has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks.
Lordship, there is interim in the 3 writ petitions.
The interim order passed earlier shall continue till the next date of listing. In which case?
The 3
in-
writ petitions.
In all the cases?
Yes.
Okay.
Obliged.
Yes.
My pleasure, my lord.
Yes.
Lordship, I beg to mention here in item 22.
Yes.
Lordship, the leading counsel, Mr. P. Soren, is indisposed. So kindly list the matter after 2 weeks.
Dispose.
Lordship,
You are Mr.
Manchong Konyak. Manchong Konyak.
Land Council submits that the leading counsel in this case is indisposed and therefore pray for adjournment of the matter. For how much time?
2 weeks time, Lordship.
For 2 weeks. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 2 weeks.
Lordship, I have a similar prayer for item 28 and 29. Here I'm the respondent number 4.
Item
27 and 28.
Lordship, I'm the petitioner.
'27 and '28.
Lordship,
You are for? You are for?
I'm for respondent number 4.
Respondent number 4.
Yes.
Mr. Fosego, you are for petitioner
I'm for the petitioner, Lordship.
seeking adjournment. No objection.
No objection, Lordship.
Okay. So here also your senior appear.
Lordship,
Okay, Mr. Okay, his name, huh? Some said his senior is the leading counsel, his senior lead who led the case is indisposed and therefore pray for adjournment, to which Mr. Fosego for the land counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after
2 weeks.
2 weeks. Okay.
Obliged.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention item 25 on behalf of IME Lordship. If this matter can be listed after 2 weeks, Lordship.
So here for what?
She's indisposed, Lordship. So if this matter can be listed after
IME.
2 weeks, Lordship.
Okay, Mr. No objection.
Yes, Lordship. Maybe
Mr.
listed after 2 weeks, Lordship.
Okay, Miss Cheng, appearing on behalf of Miss IME, government advocate, on behalf of the state respondent. Submits that the counsel appearing in the case, Miss IME is indisposed, therefore pray for adjournment of the matter, to which Mr. Toshio Longkumar, line counsel for the petitioner, has no objection. Accordingly, the prayer is allowed. List this matter after
2 weeks, Lordship.
2 weeks. Okay.
Obliged, Lordship.
Right, Lordship.
May it please the Lordship. Lordship, I beg to mention hearing item 29.
29.
Yes, Lordship. Lordship, since my senior is out of station.
You are for?
For the petitioner.
Your senior is out of station.
Yes, Lordship. So if this matter can be listed after 2 weeks.
Lordship, I'm for the private respondent, so I have no objection.
Respondent number?
5.
Okay. Miss
Asna Longkumar.
Asana Longkumar submits that our senior, A. Sophie, is indisposed, therefore pray for adjournment of the matter, to which Mr.
That is okay.
Yes, Lana counsel for the respondent respondent number 5 has no objection. Accordingly, the prayer is allowed. List this matter after
2 weeks, Lordship.
2 weeks. Okay. After 2 weeks. Okay.
Much obliged.
Yes.
For motion, item number 1. Your Lordship, please. I am appearing for the petitioners in this case.
Yes, yes.
Lords, first of all, my lords, we have filed two IE, being IE number 113 and 114.
Yes.
So, my lords, so far as these two IEs are concerned, my first submission is that we would like to make a modification in the memo of parties, and we will file a fresh memo of parties to delete all such respondents against whom relief has not been sought in these two applications.
Yes, yes.
That is my first submission, my lords.
Hmm.
Number 2, my lords, your lordship will recall, lords,
No.
in this matter,
Amendment of the application only probably we will be able to pass any order for issuance of
No.
not.
yes, but can I just explain the applications?
Yes.
Lords, first of all, IE number 113. Lords, there was a contentious issue raised before this honorable court as if the child in the ICU has suffered from serious infection. This was our contention before the court, which was negated by the hospital and their counsel on the ground that the child is not suffering from any infection. And your lordship had categorically asked them to file an affidavit. They filed the affidavit to the same effect as if the child does not have any infection. And my lords, eventually, when the medical records were issued to the parents, as per the directions of this honorable court, it was found that the statement they made in the court and the affidavit they filed to the effect that the child doesn't suffer from any infection are both false. Lords, my humble request is whether any action is taken against them or not is a different thing, but they have to be fair to the court. If there is an infection, they should be fair enough to tell the court, yes, there is an infection in the child. So my application under 379 BNSS, which is akin to Section 340 CRPC
Yes.
is for perjury, for filing false affidavit and making false submission before this honorable court, which goes into the root of the matter, my lords. My lords, regarding this, they can take their stand by filing a written reply so that your lordship can decide
Yes,
whether.
but
Yes.
since you are not seeking any relief against all other respondents,
That I have already stated, my clients will file an amended.
first, I mean,
for parties.
the
Yes.
court title. You have to file amended course title.
Yes, we will file. We will file.
Thereafter, only we will be able to pass order for issuance of.
All of it. My lords will give me 1 week's time. We will do that.
Okay. Mister,
My lord, I'm
Sachin Jain.
you are for? You are for?
My lords, me?
No, the other one.
I am for R1, respondent 1 hospital, my lord.
Okay. So, you're Mister?
Samuel Abraham.
No, for the applicant,
I am Sachin Jain, advocate.
Sachin
Jain.
Jain. You file affidavit, wakalatnama. Have you filed wakalatnama?
My lords, my wakalatnama should be there on record. I had sent it to the clients and they must have filed it.
Okay. Sachin Jain.
My lord, one submission, my lord.
Learned counsel for the applicant. Praise for. The submits that the relief sought in the application is against the respondent number 1, and all other respondents are not the necessary party to the present application. Therefore, praise for striking off the name of the respondent number 2, 3, 4, 5, 6, and 7 from the present interlocutory application. The prayer is allowed. Let the name of the respondent number 2 to 7 be struck off from the application, from the course title. Stop. The applicant shall file amended course title within a week from today. Okay.
Yes.
So list it after a week. Okay.
Yes.
My lord, another submission from me from R1.
No, let them file the amended course title first, then we'll issue notice. Okay.
Much obliged.
Maybe his lordship.
Yes.
Lordship, in respect of IA 85.
No, this is 113.
Yes, lordship.
Okay,
113.
85 not yet come.
Lordship.
Okay. Yes. What next? Next is?
There is another application, IA number 114.
Is 114.
Yes. My lords, my clients are there. They will be able to better assist whether they would like to have, because according to my understanding, my lords, respondent number 1 is enough so far as 114 is also concerned.
Here also protective can be granted, given only by the respondent number 1, it appears. Here also, I think similar.
Lords, can I just mention one thing in this application?
What is that?
Lords, because I think it also has some stakes in this hospital, subject to correction from my learned friend, opposite appearing for this point number 1. If that is so, my lords, my submission is, as per my understanding, the state government might have some control on this hospital. So in that case, if that is right, then respondent number 2 can continue as a party. This is my submission, my lords.
the action which you are alleging against the respondent is against the hospital and their authorities only, it appears.
My lords, I am saying, but my humble submission is, my lords, my understanding is that the state is also a stakeholder. It may be a private public partnership
Yes,
hospital.
respondent, what do you say? Oh, whether the state has some authority or some control over it?
No, my lordship. The chief secretary is one of the member in the society, but the society is completely independent. It is private, my lordship.
Then in
Then
that,
it is fine.
We are not getting any aid from the government.
then we'll pass similar order.
Similar order.
Similar order. Here also struck of the respondent number 2 to 7. Okay. This is after a week. Okay.
Grateful.
Okay.
Grateful.
My lord, oral submission in another issue.
Where is the 114?
My lordship observed that notice may be sent in IA 85 of 2025 in the last hearing, but it was not reflected in the order, my lord. So it can be added. My lordship observed that notice may be sent to the parties under IA 85-25, which we have filed.
85.
Yes, yes, my lord. But notice it was not reflected in the order, my lordship's order on the 15th. So it may be issued. That's all. Much obliged.
Can I make a submission? If my learned friend would press upon 85, then I would make some submission.
85 notice has not yet been issued, it appears.
Yes, Lordship.
Yes, my lordship.
It was not been issued and need not be issued, my lords. My submission
So
is,
that's
my humble submission is, my lords may kindly have these 3 applications together next week, and then your lordship may consider if notice is to be issued or not.
This appears, of course, connected.
Yes, my lords. That is what I am saying.
And then
Let all these applications be taken up together. Notice may not be issued in 85 also.
my humble submission is, as per procedure, my lordship may kindly give a direction to issue notice, then we will consider.
Maybe Lordship. Lordship, on Lordship is
this,
the submission of my senior.
This probably
On the submission of my senior.
it is possible because the main writ petition is still pending.
Yes.
Lordship, this IA 85 is connected with the writ petition.
Yes, that is why.
And then
And then because of this, I think this allegation is made.
Lordship,
IA 14, 114.
IA 14 and IF
113 and 114
has been filed only
is-
day before yesterday.
Hmm.
On 14 only,
Hmm.
on 14th of July.
Hmm.
Whereas IA 85 was filed in the month of May, on 14th May. But on 15th May, it was this Honorable Court did not issue notice. Lordship.
Hmm.
So Lordship, the IA 85 was
But-
filed on 14th
Here.
of May.
Here, what I found is, otherwise, it appears this is connected as per the allegation made in 13 and 14.
Lordship,
So-
no doubt, Lordship, but Lordship,
Hmm.
when the IA 85 has been filed way back in May, in the month of May, and
Yes.
on 15th of July, Lordship.
Notice can be issued. Notice can be issued here.
Lordship has verbally stated that notice to be issued, but in the order it's not reflected.
Notice can be issued. Yes.
Yes, Lordship.
Okay.
Can I make my submission in that case?
Yes, notice can be issued. We'll issue notice.
Can I,
Will not make
can I just,
on any, and interim also probably is not possible at this stage. Although there is a prayer, but an interim during the pendency of the writ petition, interim may not be possible at this stage. So
yes, my lord.
Your affidavit. Okay.
Lords, can I,
Hmm.
lords, can I make my submission?
Yes, yes, please.
Lord, since 85 is connected with the writ petition, and your lordship will have to consider some more IAs. So, my lords, if notice is issued, then my lords, they will be asking the court every time to, my lords, pass the order for interim payments, which is not possible because the child is in this condition because of their wrongdoings, my lords. So, my lords, keep it pending. I'm not saying dispose of, but kindly not issue notice at this stage. Your lordship may consider this next week when your lordship will hear other 2 applications also. It will not take more than 5 minutes. That's my humble submission. 1
Lord-
week will not make any difference.
May I please, Lordship? Lordship, I come page 7 of my IA, Lordship, 85.
Well, in any case, even if the notice is also issued, no interim can be passed
No,
herein
I'm
because
not
the
praying for any
repetition is
interim.
pending.
I'm not praying for any interim, Lordship. Lordship may come to my prayer, Lordship. It's very clear that at page 7, Lordship, at the prayer section,
Yes.
it's a para 9, and that therefore the present application has been filed bona fide and in the interest of justice. In view of the premises and facts stated above, the applicant humbly prays that your Lordship may be pleased to admit this application, pass appropriate direction to the writ petitioners from 1 and 2 for making part payment of rupees 50
That is
lakhs,
what I'm saying.
pending disposal of the 60 writ petition, Lord. Before the registry, Lordship, that is our prayer. And pass necessary directions to for the deposit of the passports of both the writ petitioners 1 and 2, Lordship, before the registry of the Sovereign Court until the final disposal of the writ petition. We are not seeking for custody, but for the custody before the registry, Lordship.
What I'm saying is.
So Lordship can pass
in appropriate time, because the writ petition is pending.
Yes,
Wherein
Lordship.
they are claiming the negligence and then claiming compensation. If that is granted, it will not be.
So Lordship, at this stage,
Lords may keep this pending. My lords may keep this application pending, may not issue notice at this stage because that will prejudice my right, my lords. That is the only reason. Keep it pending, my lords, no difficult.
May I please, Lordship. Lordship, the
So-
Lordship,
Okay.
may I please, Lordship, but 2 minutes, Lordship. The counsel for petitioner is saying that
Well, issue notice, the better, had Mr. Procedural Land Council for the applicant. By filing this interlocutory application, the applicant is the applicant seeks direction to the respondent number 1 and 2 to deposit a sum of rupees 50 lakhs pending the disposal of writ petition number 6K 2022 and to pass direction to deposit the passport of both the writ petitioner number 1 and 2 in writ petition C number 6K 2022 before the registry of this court until the final disposal of the writ petition. Stop. Issue notice. Stop. Since his name is Jain, appeared and accept notice on behalf of the on behalf of both the respondent number 1 and 2. No formal notice need be issued to the said respondent. However, the applicant shall take steps upon the respondent number 3
Lordship,
for the 3 to 7. Whether they are necessary party here,
Lordship, they are
they are not a necessary party.
They are part of the writ
No,
petition.
but
They are part of the writ petition.
see the relief sought by you. The relief is altogether different, not against them. Isn't it? There is only 2 prayer,
Yes,
not against any one of them. It is
Lordship.
only against the respondent number 1 and 2.
But they are part of the writ petition, Lordship.
Maybe, but then your relief sought in this IA is exclusively,
Lordship may understand that,
Oh,
Lordship. By order to
then no notice is required to be issued to them. What reply they will submit in this case?
Lordship, this honorable court, by an order, has deleted the prayer of the petitioners.
This is not connected with the prayer.
In respect with the compensation,
Yes.
which they are seeking on medical negligence. That has
Now-
been deleted. Now, Lordship,
Now,
The-
see, you are, impleading unnecessarily to these persons and then making them to file affidavit will invite something else. When you know that they are not a necessary party, especially for this IA. You may, of course, in the course title, mention that in connection with the writ petition and mentioning this name, but then especially in particular this IA, you have to implement only these 2 respondents, because your relief sought for is only against these two persons.
The petitioner's lordship.
Yes.
Just one thing. My lords, just wanted to mention one thing.
Yeah,
The learned counsel who's appearing before the honorable court physically, will he also be representing the hospital? Because Mr. Sablum Ibrahim is representing the hospital, as per my understanding, my lords. Because, my lords, the learned advocate who is appearing physically before the honorable court, my lords, is he appearing for the hospital or for the state, my lords? Because he must clarify that.
I'm for respondent one, the hospital. I'm assisting Mr.
Mr. Samuel also is appearing for the same. Yeah.
No.
Yes.
But then only one person will make an argument. Okay. So we want that notice should be issued to this other respondent also.
Lordship, because
Okay,
it's,
take steps upon
they
the
are
respondent.
participating in the read petition, Lordship.
Okay.
It's connected with the
By
read
a
petition.
registered post with AD, as well as by usual process within a week from today. Stop. At least this matter after.
After 4
2
weeks.
weeks, my lords. 4 weeks.
4
4
weeks.
weeks. Is fine.
Lordship, in respect of respondent 3, 5, and 6, I've served a copy. But in respect of respondent 4 and 7, I may be allowed to take steps.
Then the last part, the learned counsel for the petitioner submits that he has already served a copy in respect of the respondent number 3, 4, and 5.
3, 5, and 6.
Okay, 3, 5, and 6.
Yes.
Not 4.
4 is a Nagaland Medical Council.
3,
They have
5, and 6. And
3, 5, and 6, I've served a copy.
they have received.
Yes.
Therefore, no further steps need to be taken to the said respondents. The applicant shall take steps upon the respondent number 4
And 7.
and 7 by a registered post with AD as well as by usual process within a week from today.
Lord,
Release this matter after 4 weeks. Okay.
oblige my lord.
Yes. This is 85. Okay.
Lords, there is one more request. Your lordship will recall, your lordship had heard an application IA 65, which went on for the whole day. That
IA
is
5.
IA 65, my lords,
Hmm.
filed by the petitioner. It is against one advocate, Ms. Koza,
Yes.
who, yes, my lords, who forged our signatures and filed an application withdrawing certain prayers from the writ petition.
So here, what I found, matter involves with the dispute of fact, the allegation. And then you have also made an application or complaint before the Bar Council.
My lords, exactly, that was my submission.
Process.
Lords, yes, my lords.
That
So,
is
my lords,
Hmm.
no, my lords, can I just, lords, 340 CRPC is a criminal proceedings which is initiated after a preliminary inquiry is conducted by the registrar of the Honorable High Court and a complaint is made when trial goes on. The Bar Council is a disciplinary proceedings which is civil in nature and there is no overlapping between the two. Irrespective of the outcome of the Bar Council proceedings, my complaint before this Honorable Court is fully maintainable as per the catena of judgments rendered by the Honorable Supreme Court and this Honorable High Court. So, my lord, this is an independent remedy, criminal remedy. And my lords, if she has forged my signatures, then irrespective of what the Bar Council says, I have my independent right before this Honorable Court. If on inquiry, of course, it is found that she has not committed fault, then your lordship can put the entire onus on me. But at least, my lord, there has to be an inquiry because matter is very serious. She has forged my signatures. She has withdrawn the prayers. And my allegation is that she has been won over by the hospital councils, man. By the hospital, I'm not so sorry, my lords. And she has, under that influence, she has caused irreparable damage to my fundamental rights. So there has to be an inquiry.
Lordship, allow me to assist this court, Lordship, as an officer of the court and also as the accused, Lordship, an unnecessary party dragged into the case, Lordship. This IA in the first place is not maintainable. I'm not an interested party in the writ petition, Your Lordship. I'm neither a party in the respondent in the or any party in the writ petition. Now, the basic principles underlying the filing of IA, interlocutory application, what is it, Lordship? These are interlocutory applications are filed. Purely, it has to be in connected with the writ petition, Lordship, not otherwise. There are other remedies which are available, Lordship. If they are aggrieved, why didn't they go ahead file FIR? Subject to proof, Lordship. Burden is on them. I have also, as this court has directed, Lordship, included me as a party, this IA is not admitted yet, Lordship. Now this court has directed me to file objection. Accordingly, respectfully, I have done that. Placing before this court,
Have you filed affidavit?
Lordship, yes, I have filed two affidavit with overwhelming evidence, Lordship. Now, Lordship, if they are aggrieved, they should be appealing order dated 18/2 of 2022, wherein the Lordship, if you recall, on 1st April of this year, Lordship, this IA was heard at length, Lordship, whereby before going to the law, the aspect of law, I have apprised and assisted this court the consequential orders, Lordship, the judicial orders which were passed consequential to order dated 18/2 of 2022, Lordship. Now, the petitioners, initially there was only petitioner number 1, Mr. Tejangole, Lordship. With due instruction, Lordship, they have instructed me to appear. I have fully, in compliance, in obedience of the instruction, appeared before the court, Lordship, and then even obtained relief. For 3 days, I have appeared. And as per the direction of this court, Lordship, applications were filed, Lordship, which I am not answerable, Lordship, because they themselves were filing it, they were preparing the applications. My colleagues were filing it, Lordship. My instruction and the agreement to the extent to assist them is for argument only, Lordship, for making appearance only. And I did accordingly. I did justice, Lordship, and because of all this consequential order, their daughter is alive today, even yesterday. Petition number 2 was submitting through the intervention of this court. Their daughter is alive. Miraculously, Lordship. And so after doing a favor, Lordship, for them, I have never breached any professional misconduct, Lordship. I have not caused any professional misconduct. What was the instruction? I have placed overwhelming evidence. On the last occasion, the judicial orders were read out to this court, Lordship. Assisted, the clarity was given, Lordship, where this court was also opinion that...
What evidence you have filed?
Lordship, I have in sequence, Lordship, I have filed a court's order directing that the prayers be deleted, Lordship. They have given all full instruction, Lordship. Now they are saying that it was me, I have forged the signature. And Lordship, before delving, even going there, Lordship, allow me, Lordship, there's a Supreme Court judgment where Section 340 of CRPC has clearly been explained, Lordship, and how it should be used. Now, this cannot be used against litigants, Lordship, or the affected parties, wherein the Supreme Court has said that to exercise Section 340 of CRPC, the object is the quote, Lordship, the administration of justice. This is what the Supreme Court has said, Lordship. Parties, if they agree, they have other remedies to exhaust.
You have anything to submit? Any more thing to submit? Mr.
Me?
Yes.
Yes, ma'am. Lords, we have to make submissions on these applications because not only she forged our signatures, even the Delhi Council who was appearing has told us that even her signatures have been forged, which is a very serious matter, my lords.
Lordship, is she here today?
Very root of the administration of
today, Lordship. These are hearsay, Lordship. These are not admissible before this court. I have placed overwhelming evidence, Lordship. Allow me to kindly take you through this. My colleagues who were filing, assisting in them in filing, they have given the statement saying that everything was done under instruction. On the last day, on the 1st of April 2025, Lordship, the petitioner number 1 himself admitted. These are on record, Lordship. It's on YouTube, it's live stream. It's on record. He himself stated he came to HR and Human Rights Law Network Nagaland Unit's office to append signatures, Lordship. Let us not forget, that was a time during when the COVID-19 was still pandemic, Lordship. There were travel restrictions were there. The instruction given to me to appear was given through Zoom, Lordship. Now, Lordship.
Lords, can I suggest one thing?
Just a
Not
your affidavit. Affidavit. Hello.
Lordship, I have
It-
filed
65.
objection. Yes.
65.
As directed by the
Objection.
court.
Objection in 65.
65, Lordship. 65 of 2025. And also additional, Lordship, counter affidavit to the rejoinder filed by the applicant's, Lordship. I have also citations, Lordship, wherein their action is clearly indicating that it's an abuse of the process of court and abuse of law, Lordship. This court has to view this with seriousness, Lordship. Lordship, for clarity's sake, please turn on to page number 115. I don't know what it is. One 115
What is
onwards, Lordship,
These are
of
what-
my objection, Lordship.
This is court order. Court's order.
This is the court order, Lordship.
Yes.
Herein, Lordship,
Yes.
if they are aggrieved, they should be challenging this order,
Right,
Lordship.
right. That is true.
Now they're saying that another counsel has appeared. I had no instruction to appear. Did that?
By this order,
The prayers
just a minute.
was made for deletion of the prayers for medical negligence compensation, Lordship. And this court has also struck off the name of the doctors who were.
Just a minute. Mr. Jain,
Yes, my lords.
have you filed an application for modification of this order?
Lords, this order, my lords, in my humble submission, as per law, this order is not appealable.
No, modification of order, modification
Yes,
of.
yes, yes, IA 58, we have filed, IA 58, my lords.
Under what provision? It is not appealable, Lordship.
Hmm?
It is any party agrees to the orders passed or judgment passed by the order by the court is appealable, Lordship. What kind of submission is this, Lordship?
They can file an application for modification of the order.
Exactly, Lordship.
We have filed IA 58.
Petitioners
and
are
I learned
undermining the service, professional service rendered by the advocates, Lordship.
My lords, actually, there's too much of anxiousness on her part. Let me.
Exactly. I am anxious.
this,
Why
my
should I
lords.
not be?
No, my lords.
Just a minute, no?
My lords, let me tell, my lords, because it is a consent order, it cannot be appealed. So there has to be an application before the same court which passed the order. Consent order cannot be taken into
You can
account.
also file.
We
They can
filed-
also file an IA for modification of the order.
No,
We filed IA 58, my lords,
Okay,
please.
agree.
We filed.
don't reply one by one, okay? Let him complete first. Hmm.
My lords, we filed IA 58. In answer to your lordship's query, we filed IA 58 for restoration of these prayers and IA 65 for taking action against the advocate who has done this damage to us. Not only she forged our signatures, she forged the signatures of our advocates from Delhi also. This is a serious matter, my lords. We will not trouble the court otherwise.
That question of dispute of fact. Hmm.
Lords, that is why the section 340 provides that in
Anything
case.
else? Anything else other than that? Anything else?
Lords, then we have to place before my lords the entire application and the manner in which he has filed the reply, our rejoinder, so that your lordship can reach a conclusion in that case. My lords, if your lordship permit me, then I'll place before my lords each and every fact of that application and the background in which that application has been made, the reply that is in file, which to a great extent, my lord, that will help court understanding the manner in which our erstwhile advocate, Ms. Koza, she has.
After filing this application or before,
Yes, my lords.
you have lodged complaint before the Bar Council.
Lords, Bar Council complaint is a different remedy, my lords.
Take a seat, please.
Yes, Your Honor.
Take a seat. Your advocates are representing you. Don't worry. Whose signature was forged, according to you?
Lords, my client's petitioner signatures were forged.
Two petitioners.
Lords, one of them, the husband's signature, the petition number 1.
Okay. Petitioner number 1.
तो उसमें मेरे नाम से जोड़ दें। उसकी फाइल निकाल दे।
Yes. Anything, any other thing?
I have evidence, Lordship, to prove that I have not forged. Lordship, kindly hear me,
We have
Lordship.
heard. Last time we have.
Last time also you have heard.
Yes, yes,
Lordship.
we have heard. I've heard. So any additional submission? Last time it was extensively heard.
Lordship, yes.
The petitioners, both the petitioners were present in persons. Okay.
Lordship, also as to the question reposed, they haven't replied.
Notes, can I say,
Wait,
my lords, because if these
There
players,
are complaint.
Other than what was already submitted, is there anything additional submission?
Lords, because though that day your lordship will recall the arguments were not concluded. It was already 4 o'clock, and there was one matter which was to be heard by my lords. So your lordship had kept it parted, and my lords, the submissions were yet to be concluded. So your lordship can see, my lords, 3 things, my lords. First of all, she forged my signatures. Secondly, she forged the signatures of my lawyer from Delhi. This is at page 35, my lords. And she has made a statement herself to me that her signatures are not her signatures, and that those have been forged by the local council of the Kohima bench. Number 3, my lords, the Wakalatnama has been tampered with. Your lordship will find it at page 35 of this application.
Just a minute. Page 35
Yes, my lords.
of the application.
Of this IA 65, my lords.
Yes, then.
After doing these 3 activities, forging my signature, forging signature of the advocate, and tampering with the Wakalatnama, she withdrew all the prayers in the writ petition.
Okay. Yes.
So, my lords, I filed 2 IAs. One, to restore these prayers, because unless those prayers are restored, my lords, my writ petition cannot survive. She says that the prayer apropos the medical negligence should be deleted. She says the compensation should be deleted. She says inquiry should be deleted. Everything has been deleted. Now nothing remains. And your lordship sees the child is in vegetative state, lying in the hospital for 5 years. And the lawyer is doing such a conduct, completely, my lords, taking away all my fundamental rights to continue with the treatment.
Okay, just a minute. What is the status of the before the bar council? Just one information. What is the status of the case before the bar council?
Lords, as per my understanding, sir, lords, the petition would be able to, the bar council is keeping it pending,
Okay.
subject to the orders of this honorable court.
Lordship, kindly allow me to apprise this court.
No, just a minute.
Lordship, yes.
Oh, you have heard you?
Yes,
Already heard. Don't worry.
Lordship.
Yes, Mr. Jain. Any? Yes.
My lords, my submissions are twofold. Number first submission is my IA 58 should be allowed so that prayer can be restored. My lords will appreciate one thing. Whether those prayers can be eventually allowed or not is in the hands of the court. I am not saying those prayers in the writ petition should be allowed. But my only humble submission is those prayers should be restored so that the court can consider.
This present case, submit in this present case.
Yes, my lords.
Give liberty.
I'm sorry, my lords.
That will give liberty to you to file appropriate application before the court for restoration.
We have done that, my lords. IA 58.
Okay. So that will be considered separately, but submit here in the.
So, my lords, both will go together because your lordship had observed it in the past also. IA 58 and 65.
This cannot be. It cannot be exchange in exchange of the present.
No, not really, my lords. I'm not even.
Mr. Jain.
Suppose.
I'll take the relevant portion, huh? Mr. Jain, Learning Counsel for the applicant. Para. Also had, so not para, huh? Also had Miss Koza. What Koza? Koza, huh? Nityo Koza. Appearing
In person.
in person. Respondent number 7 appearing in person. Huh? Stop. Huh? The interim application. This interim application. This interim application. No, applicant. So petitioners. Direction. The thorough investigation into the alleged misconduct and acts of by their former advocate, respondent number 7, who is said to file an interlocutory application. What is the interlocutory application? What is the number of the interlocutory application?
65 of 2022.
65 of 2022.
25, Lordship.
2024.
Lordship. 2024, Lordship.
24.
Yes, it was filed last year, Lordship.
No. By which it
yes,
have
Lordship.
drawn.
Yes.
By which order it was?
Prayers were deleted by this court by IA 18 of 2022, Lordship.
18. IA 18.
10th of March 2022.
Void order dated 10th.
IA 18
2022.
of 2022. Without their authority. Without their authority. Their consent and authority, resulting the deletion of a key relief originally sought in the writ petition by order dated, which order?
March 22.
10/3
10th of
10/3
10 March, Lordship.
2022.
22.
Stop now. Para. The applicants applicant's son alleges that the signature not only of the petitioners, but also of the learned advocate stationed at Delhi was forced by the respondent number 7 and Wakalatnama and also tempered the Wakalatnama and the Wakalatnama and court records were also tempered with in order
The allegation is only Vakalatnama, Lordship,
to
not
seek
court records.
modification of the prayer court records. See the prayer, page 17 of the application. So modification of the prayer clause through an interlocutory application that was allowed by this court on 10/3/2022. It is contended that the said act has caused serious prejudice to the petitioners, and it diluted the core relief sought in the writ petition, and also obstructed the parts to justice in a matter involving grave and human rights issues concerning the petitioner's minor child, who is under long-term medical care at the hospital of respondent number 1. Number 1. In the hospital, not of cut down. Okay. Stop. Para. The applicant has also lodged complaint, and then in this regard, the applicant has also lodged complaint before the chairman of the Bar Council of Nagaland, Mizoram, Arunachal, and Sikkim. Under section 35 of the Act 1951 and section 463 of the Indian Penal Code. Alleging professional misconduct, forgery, and which is stated to be, which according to, which is informed by the Land Council for, sorry, is informed by the respondent number 7 is under process And the proceeding has been concluded in the said, concluded, and the judgment is, the order is reserved. The order is yet to be passed. Okay,
Lordship.
stop. The respondent number 7 contested the case by filing affidavit with evidence denying the allegations, and has stated that she was approached by the petitioners and acted under their instruction in good faith as part of a, you said that it was a pro bono service
Lordship, it is,
Okay.
it was.
of a pro bono engagement through the human right network. What was that?
Human Rights Law Network.
Human rights law network. You are in charge of the Nagaland.
Lordship, yes.
Okay.
I was, Lordship.
Okay. So, para. It is submitted that the petitioners has now engaged another advocate of their choice. And no longer represented by the earlier advocate, respondent number 7, namely the respondent number 7 staff. Para. Okay. Having heard the parties and peruse direct on and on perusal of the record available before this court, comma, this court is of the view that the matter involves disputed questions of fact and allegations, which falls within the purview of the bar councils. Of the Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, before which the petitioners already lodged complaint against respondent number 7. Appropriate investigation. And then, who is the appropriate authorities? Stop. This court cannot enrich jurisdiction. Can
I make one submission on this one? Just one submission.
Just a minute, comma, conduct a fact-finding inquiry into charge of forgery or misconduct by a legal practitioner, comma, unless it arises directly and conclusively from court records. Stop. Para. However, comma, given the seriousness of the allegation and its potential impact on the integrity of court proceedings. And what is constitutional right. This court is of the opinion to give the following direction. What I'll give direction is to register will verify. Okay, one, the register judicial shall verify whether the interlocutory applications verify whether the interlocutory application in question bears the signatures of bears the signature and the authorization of authorization in compliance with the rules, and whether any irregularity appears on the face of the record. Stop. The registry shall submit a brief report in the seal cover within 3 weeks from today. Next. 2. Since the complaint filed by the applicant before the Bar Council of the Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim has proceeded. Sorry, just since the complaint filed, since the proceeding of the complaint filed by the applicants before the Bar Council of so is stated to have concluded, and the order is reserved, the Bar Council shall expedite the same. The Bar Council shall conclude and decide expeditiously, preferably within 4 weeks from today. No, within the period of 3 months from today. Stop. The petitioner is advised to seek correction or recall of any prior order passed on the alleged authorized interlocutory application. Liberty is granted to do so by filing appropriate application. Stop. In this regard, the Land Council for the applicant submits that the application has already been made, which is registered as
IA 58 minutes. IA 58.
IA 58
Yes.
of 2000.
Minutes 24 minutes 22.
2022.
Sorry, minutes. 20 should be 24 minutes. I'm sorry.
2024. Okay, start. Next. In the earlier, number 1, seal cover, huh? The seal cover shall be placed along with the main writ petition. The seal 1, huh? The register direction to the registry, huh? The seal covered envelope shall be kept along with the main writ petition. Main writ petition. Okay, now come back last. The interim application stands disposed of. In the no observation in this order shall be construed as expression any opinion on the merit of the pending complaint or criminal proceeding. Okay. Since you have already filed application, that will be dealt with, and probably that will be considered only. Okay. This interlocutory application.
Lordship, a copy of the order may be furnished to me, Lordship. To take
Let
appropriate
a copy
action.
of this order be furnished to the parties, including the Bar Council, the President stroke Secretary Bar Council of the Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim for necessary action. Okay.
Obliged, Your Lordship.
Grateful, man.
Yes.
Thank you, Your Honor.
64. Yes.
For motion, item number 2.
Yes.
It please, Your Lordship.
Hmm.
The instant petition is praying for regularization of his service as directed by the Honorable Court by order dated 15/2 of 2010, passed in WPC number 141 of 2008. Lordship, may kindly see Annexure A, page 19.
Yes.
Lordship, the petitioner was appointed as peon cum chowkidar on
Have you filed a
conflict
typed copy
basis.
of this order? Okay. Yes.
For a period of 1 year on land ownership basis.
Oh,
During the pending.
yes, Ms. Cham.
Lordship, at this stage, the notice go, Lordship.
Will issue notice? Okay. Hard Miss
Rebecca.
Rebecca, Land Counsel for the petitioner.
Lordship, I have an interim prayer.
What is the interim prayer?
That the pendency of the writ petition shall not be a bar for the respondent to consider my service for regularization. That the pendency of the writ petition shall not be a bar for the respondent.
Okay. Rebecca, Land Counsel for the petitioner, huh? Start now. By filing this application under Article 226 of the Constitution of India, the petitioner seeks direction to the respondent authorities to regularize. The petitioner is he or she his service in due compliance of the order dated 15/2/2010 passed by this honorable court in WPC number 141 within bracket K bracket close stroke 2008, which read as under the relevant the relevant portion of the direction order is reproduced here in below. So this is, where is the direction? Within inverted comma, since the petitioner has already been appointed as peon cum chowkidar on contingency basis, comma, the relief sought for by the petitioner has already been granted, and therefore, comma, this writ petition stands closed, stop. However, comma, since the appointment of the petitioner is only on contingency basis, comma, the department should consider his appointment on regular basis on expiry of the term. Inverted comma close. Stop. Para. The petitioner also seeks for direction to the authorities to grant scale of pay as is being paid to the regular employee. Stop. Para. Issue notice. Returnable by 4 weeks. Stop. Since Ms. Chen, landed government advocate, accepts notice on behalf of the
1, 2, and 3.
state respondent number
1, 2, and 3.
1, 2, and 3. Now, all the state respondent number 1, 2, 3. No formal notice need be issued. However, the petitioner shall furnish requisite extra copies to the land council, the land government advocate during the course of the days. Stop. Para. List his matter after 4 weeks. Stop. Para. Before list is made, in the interim, it is provided that pendency of this writ petition shall not be a bar for the respondent to consider the case of the petitioner for regularization of his service. List is matter after 4 weeks. Okay.
For admission, item number 3.
Please, Your Lordship, the matter was disposed of today, but my clients have instructed me to seek some time because some negotiation is going on between the two parties.
Okay.
Yeah, so 3 weeks time may be given, Your Lordship.
Okay.
I am for the respondent.
You are for?
I am for the respondent.
You are for respondent?
Private respondent, and petitioner is, Fosico is representing the petitioner, yes.
Both.
Yes.
The land council for the petitioner, Mr. Fosico Forte, and Mr. Mr. Yes.
But my name has not been.
Yes, that is why.
As, yeah.
Why you have filed wakalat number?
Yes, in the
Okay,
wakalat
Tompok Mognar land council for the respondent are present. It is submitted that the negotiation between the parties is going on for settlement. Therefore, praise for deferring the matter for 4
3
weeks.
Your Lordship.
For 3 weeks, for 3 weeks, stop. As per it, comma, this matter after 3 weeks, stop. The registry is directed to, the registry shall reflect the name of Mr. Tongpong Pongnar as land counsel for the respondent number
5.
5, okay, in the cause list, okay.
Much obliged. For admission, item numbers 4 and 5.
Your Lordship, in this matter, all the pleadings are completed. If the matter can be listed for hearing, all
Uh,
pleadings are completed
okay.
in this matter. If the, we will not be filing our reply, Your Lordship, so. all the
Okay,
pleadings
Miss
are completed.
Kim Pianyu, land counsel for the petitioner submits that the petitioner is not filing affidavit in reply. In view of the above, the pleadings are completed and the matter is ready for hearing. Stop, list the matter for hearing after 4 weeks. Ms. Cheng, land counsel for the, Ms. Cheng, land government advocate, appears on behalf of all the state respondents. Okay.
Obliged.
For admission, item number 6.
May I please acknowledge? My lord, the matter is fixed for admission hearing, my lord.
What is this matter about?
My lord, here the case of the petitioner is that the petitioner was appointed as work judge bill assistant on 10 March 2015, my lord. And the
2015?
Yes, my lord. 10/3/2015, my lord. And she was posted under the establishment of executive engineer, Gauhati division, my lord. And after the appointment, the petitioner was serving there. And what happened is that, my lord, on 2017, my lord, that is 20 December 2017, my lord, Annexure B, my lord. The state respondent has passed the impugn order dated 20 December 2017, page 17, my lord. Type copy is it.
What is this order? What is this order?
Type copy is page 18, my lord. My lord, by this impugn.
She was transferred.
She was transferred to the office of the respondent number 5.
Yes.
My lord, however, this impugn order was never communicated to me, my lord.
Transfer order?
Yes, never communicated.
Like who has gone to transfer then?
My lord, the respondent number 3 has got this impugn transfer order. However, I was serving under the state's under the.
So you were not in the duty. You did not attend the duty.
I was performing in the area place of posting.
Where?
Gauhati division, my lord. My lord, though the respondent number 3 has got limiting transfer order, I was never communicated, nor to the controlling officer of the Gauhati division, my lord. And I was allowed to attend in the office of the respondent number 4. And I was showing my salary from the office of the respondent number 4, my lord.
Even after transfer also?
Yes, my lord.
For how long?
For my lord, only last year, in the last part of 2024, my
you
lord.
were transferred in the year 2017.
2017, yes.
And you drew salary from the respondent number 4 since till
March 2024, my lord.
Okay, then what happened?
My lord, I was not aware of that. And when I visited the office of the respondent number 3.
Ah,
I was informed that I was transferred to the respondent, to the office of the respondent number 4, and I was issued with the termination order. There is on 2012, 2023, my lord. 23, my lord. The
On what
termination order is at page 19, Annexure C, my lord.
Have you filed affidavit?
Yes, my lord.
Then it can be heard only. Today,
Yes, sir.
okay.
So, my lord, Annexure C is the termination order.
Just a minute.
Yes. ma'am. Annexure C, page 19.
Just a minute. Huh? Just a minute.
Yes.
Where is your appointment order?
Annexure A, my lord. Annexure A.
A is your appointment
Page-
order.
Page 15, Annexure A, type copy is page 16.
Okay.
my lord. Yes, my lord.
Yes.
By this order, I was
Just a minute, huh?
appointed.
Okay. This is appointment order. This is in the year 2015.
Yes, my lord. 10 March, 10/03, 2015, my lord.
Appointed as what?
As bill assistant, my lord.
Okay.
Yes.
This is regular only.
Appointed as, it's written as WE, my lord.
WE bills with carrying with a scale. This is regular only, regular appointment. Okay.
Yes, ma'am.
Okay. Then you join. Where is the joining report?
I have not enclosed the joining report, my
Why?
lord. My lord, as I was working there and there's no issue about my joining.
No, unless you join, how do you? After joining report only, you will resume your duty.
Yes, my lord. Annexure, my lord, kindly please to come to Annexure B, my lord. Type, yes, page 17, type copies, Annexure A. And page 18, my lord. Annexure B.
Annexure B.
Yes, I've joined under the establishment of EE Gifford Division, and while I was serving there, I was transferred by Indian order dated 2012, 2017, my lord. Married, my lord.
Yes. Page 18.
Yes, page 18, my lord. Office order number so and so, interest of work, Srimati Yotingla Sankam, WC Bill Assistant under the establishment of Executive Engineer, Electrical Division, Gifri, is hereby transferred to Executive Electrical Division, Mon, with immediate effect, my lord. This is the transfer order.
Yes, then?
My lord, as the state respondent has not communicated this impugn transfer order to me, my lord, and as well as to the respondent number 4, I was allowed to work.
No, what is your the salary, last salary drawn?
Last salary drawn is at page Annexure F, page 25, my lord. Page 25, my lord. Type copy, page
25.
Yes, my lord. My lord, division Gifri Electrical Division EE Gifri Subdivision SCE Gifri Fongro. Now, on the right side, it's written work charge paid bill for the month of March 2024, my lord. And my name is reflected at serial number 14, my lord.
Just a minute. Sir. This is salary.
Yes. Month pay bill for the month of March 2024.
Your name is at serial number
Serial number 14, my lord.
14.
Yes, my lord. And here, my lord, in transfer order was issued in the year 2017, and the order was never communicated to me nor to the respondent number 4. And I was attending my duty and drawing my salary from the office of the respondent number 4. And my lord, in the year 2023, that is 2012-2017, I was terminated on the ground that I have not joined the office of the respondent number 5, my lord. That is the ground where my service has been terminated, my lord. And my lord, here,
Terminated 7%.
yes, my lord.
Where is the notice issued to you?
Notice was not issued to me, my lord. No opportunity was accorded to me before the termination order was issued, my lord. And your lordship, you kindly come to page number 26, Annex G, where this is the attendance register.
Just a minute. Huh? Your name is in the termination order. Your name in serial number 1. 2.
My lord, kindly.
Yongtila.
Yotingla, yes, my lord.
Yotingla.
Yes, Yotingla. Serial number 2, my lord. Serial number 2.
Yes. What was the next?
Annex G, my lord.
Annexer?
Annex G, my lord.
What is Annexer G?
This is the attendance register where I was performing my duty regularly, my lord, in the office of the respondent number 4, my lord. Annexer G, page 26. 26.
26.
Type, yes, my lord. Type copy is at. However, here your lordship will find that you think the petitioner serial is at 7, serial 7 in the register, attendance register for the month of October, my lord. And also the following one is the
your name in serial number
7, my lord.
7.
Yes, one. It's not legible, so I made a type copy at page 27, my lord. This is for the month of October, and below is the attendance which is for the month of November 2022, my lord. And here also my name is appearing at serial 7, my lord.
Yes.
And page 28, my lord. Type copy is at page 29, and this is for the month of December 2023 and January 2024, my lord. My name appears at serial number 7, my lord. And now page 30, type copy is at page 31. This is the attendance register for the month of February 2024, March 2024, and April 2024, my lord.
So you attended till, where is the last?
Last is May, my lord, May.
February till May?
Yes. Yes, next page 32.
Your name is? At
Now,
serial number 10?
at page 33, my name is at serial 10, my lord. For the month of May 2024, my lord.
Okay.
Yes,
Then?
my lord. Here, I was terminated from the service on 2023. And even that termination order was not communicated to me, my lord, and also to the respondent number 4. And even after the termination order was passed, I was performing.
You were performing duty with respondent number 4?
Yes, my lord.
So your appointment, just a minute, huh?
Yes.
Tuensang?
Kifri, my lord.
Kifri?
Yes, my lord.
But this appointment order says it's Tuensang.
Yes.
Wait, okay. There are the
Earlier, Kifri was under Tuensang.
now
But-
Kifri was under Tuensang.
Yes, my lord.
Now-
My lord, executive, it was, I think, Kifri got district in the year 2023 or 24. And the whole affairs of the electrical department was looked after by the Tuensang.
Executive engineer, before.
Yes, and I,
Executive engineer, electric division, Kifri, Nagaland. Electrical division. Executive engineer, E division, Tuensang. It was renamed. Have you stated in your petition?
no, my lord.
How do we link it then?
From the.
You should have clarified in
Yes.
your petition that it was renamed after the bifurcation of the district or creation of the new district. Now, how do we say?
There's a letter from the EE Kifri, my lord.
Hmm?
Letter from the EE, my lord.
What?
Letter, a letter.
Where?
My lord, here I've submitted a letter dated 2 May 2024 and page 21, Annex T, my lord. After my termination order and after receiving the impugned termination order, I wrote a letter to the Chief Engineer-in-Chief, Power Department, Kohima, my lord. Through proper channel, reference so-and-so, and subject here is miscommunication in issued of transfer order and termination from service day of my lord. I've submitted a letter to the Engineer-in-Chief Department through Executive Engineer Kifri for reinstatement of my service. And after this letter, the in the Executive Engineer Electrical Division Kifi has wrote a letter to the forwarded my representation to the respondent number 3, my lord. Annexure E, page 22, is the letter from the Executive Engineer Kifi Division, my lord. Mary.
Yes.
Lordship. My lord, let me first take your lordship to Annexure T21. That is my letter, my lord. To the Engineer-in-Chief Power Department, Kohima, Nagaland, through the proper channel.
No, that you have already read.
No, I've not read the content of my.
What you were reading?
The heading, the upper portion, the heading only.
Okay, you want to read?
Yes.
Okay, read it.
Yes. Subject: miscommunication in the issue of transfer order and.
You have already
termination
read
order.
it.
Yes, they're all.
I heard.
Sir, I was appointed as speed assistant white order bearing number so and so. Did it then?
Come to 22.
Yeah.
What is this? Forwarding.
Forwarding. Okay. To the Engineer-in-Chief Department of Power, Nagaland, Kohima, subject regarding termination of service in respect of Srimati Yotingla, Sangdam Bill Assistant, work charge under key-free electrical reserve. In writing and reference to the above cited subject, I have the honor to forward herewith an application received from Srimati so-and-so Bill Assistant under key-free electrical division regarding her termination from service as Bill Assistant work charge. In this regard, it is to state that she is regularly performing her duties under STO. However, it is reported that her service has been terminated for not joining Mon Electrical Division on transfer white order so and so, dated 2017, which she claimed was uninformed, no a copy received. Despite her termination from service, white order so and so, dated 27 October 2023, she was yet again unaware and continued to perform her duties regularly till date. In light of the above cited reason, it is sincerely requested to kindly reinstate her service as it has been resolved due to gap in the official correspondence.
Anything else?
My lord, notice was never issued to me, my lord.
Okay.
And I was not being heard, my lord. And
so it appears it was not communicated.
Paragraph number 4, if I may rely, Lordship. Paragraph 4, 6, 7, and 8, Lordship. I'll be relying on this, Lordship.
Just a minute. Submission of the cost. What is this? Other affidavit in opposition. Affidavit in reply. State respondent number 4. No.
I first don't.
Okay,
Paragraph 4. I'll be relying on paragraph 4, 6, 7, and 8, Lordship.
4, 6, 7, and 8.
Lordship.
6.
So it's, Lordship, as far as the contention that the transfer order was not communicated to her, is that, Lordship, see, if you can clearly see, Lordship, in the writ petition, page number 17, annexure B, Lordship.
The writ petition?
Yes, Lordship.
Page number?
Page number 17, Lordship. That copy at 18.
Yes.
A copy was sent to all the concerned persons, Lordship.
Okay, that is true.
Yes, Lordship. And as far as the termination order is concerned, Lordship, if Lordship may kindly come to page 6 of my affidavit in opposition, Lordship.
Yes.
Mary, Lordship.
Yes.
To the Executive Engineer Electrical Division, termination of service in respect of Srimati Yotingla Sangdam, OMS Field Assistant. The Executive Engineer Electrical Division replied the letter in reference forwarded the letter submitted.
This is after receipt of the letter from the Executive Engineer.
It was sent on 24th of May, Lordship.
Yes, after that is,
Yes,
uh,
Lordship.
yes, reply to the EE letter.
Reply to the letter written by the EE.
Yes, sir.
Okay, yes, please read.
The Executive Engineer Electrical Division keep write the letter in reference forwarded the letter submitted by Ms. Srimati Yotana Sangam, OMS Bill Assistant under Executive Engineer Electrical Division 1, questioning this office orders such and such, claiming the person concerned and the Electrical Division Kipri have not received the orders, which is unintelligible. The seniority list of the department is dispatched to all divisions each year, giving a 90 days time to apply for correction if any data error exists. This office have never received any letter from the person concerned or electrical division, Kipri, for redressing her place of posting featuring under MON since 2018. Thus, her claim of not having received copy of order is untenable, Lordship. Moreover, despite repeated reminders to submit money disbursing return regularly, electrical division Kipri have not been submitting the same, and therefore this clearly is not an oversight by this office, Lordship. So, Lordship, we have done what needs to be done, Lordship. The contention that no transfer order was sent to her, Lordship, and the termination order not sent to her, Lordship, this is totally denied, Lordship.
And my lord,
Wait, okay. Yes. Anything else?
That's all, right, Lordship.
So this,
my lord, the
you are posted at
Kifri.
Kifri, Kifri in the main headquarter.
Yes, my lord.
Okay.
My lord,
How long it take
from
to
here,
reach one letter, the office letter? This is from
254 kilometers from Kohima, my lord.
Okay.
Yes, my
So
lord.
it did not reach there even after.
I don't know whether in what ways they have communicated. But however, see, my lord, here,
And I
as
think
per
there is a serious communication problem. And then you see the executive. Have you seen the letter? Have you seen the letter of the executive engineer? Ms. Chang, come, please. Page 22 of the petition. She is regularly performing her duties under so and so. However, it is reported that her service has been terminated for not joining MON Electrical Division, which she claims was uninformed, nor a copy received. Despite her termination from service, she was yet again unaware and continued to perform her duties regularly till date. See, she was performing her duty.
My lord,
In light of, just a minute, is sincerely requested to kindly reinstate her. See, the executive engineer under whom he or she, it's she was performing duty. And then the executive engineer is also unaware about that. Otherwise, the executive engineer, had the executive engineer knew, would have released her, isn't it? But that also have not done. No notice was issued for termination also. I think there is a serious miscommunication.
my lord.
Okay. So, what? I'll take the structure. Okay. Hard, Mr. Mr.
My lord.
Land Council for the petitioner.
My lord, here I have the prayer that I made, my lord, is to question
Just wait. Please take seat. By filing this writ petition under Article 226 of the Constitution of India, the petitioner challenged the impugn termination order dated. Now, impugn, this is 2012 is, what order is this? 2012.
The first impugn order is the transfer order, my lord.
Okay. 16. Where have you challenged the transfer order?
Page 12 of my.
No, where have you challenged the transfer order? In the prayer.
Annex.
Not challenged. Okay. The impugned termination order. Number ENCP. No, this is transfer. Number, huh? ENCP stroke E dash 314 stroke PT part, huh? Dash Roman 2 stroke 3554 dash 57 dated 27/10/2023.
My lord, my apologies.
In respect of. Wait, you sit. You sit down. Take your seat.
Impugned transfer order. It's in annexure.
Annexure is there, but you.
I've made a pleading.
Where is your prayer?
My prayer, the first one, my lord. My prayer number 1, my lord.
Prayer number 1 is set as an impugn.
Order bearing number so and so.
2012. 2012 is a year. 2012
is my transfer order, my lord.
2012 is transfer order.
Yes, 2012, 2017, my lord. This is my transfer order. And my termination order is 27/10/2022.
2012. Okay, then I challenge the impugn transfer order, the order number, huh? First, transfer order number ENCP stroke E dash 325 stroke 5057 dash 60 dated 2012/2017. And the impugn termination order, huh? Same date is so and so, huh? Para, the case of the petitioner is that the petitioner was appointed okay. The case of the petition is that by an order number, an order dated 10/3/2015 issued by the chief engineer is a respondent number 3 is engineer in chief. It says chief engineer, but here you have included engineer in chief, Department of Power, chief engineer transmission. And no, it's different. It was issued by somebody. This is transmission and generation. You have not implemented the authority who has appointed you. Whether the chief engineer transmission and generation has been renamed as the engineer in chief.
My lord, at the time of appointment, my lord, chief engineer is appointing authority. But after some years, the post of chief engineer has been upgraded to engineer in chief. Now
okay, now
chief engineer in chief is the
okay, then
authority.
Leave that now by the respondent number 3. Huh? By the respondent number issued by the respondent number 3. The petitioner was appointed as W stroke small e, huh? Stroke bill assistant under executive engineer within bracket E division Chuan Sang. Stop. Pursuant to the appointment order, the petitioner joined his service and was performing her duty in the said establishment. Stop. Para. The further case with the petitioner is that she was sorry, the respondent number 3 issued an order number ENCP stroke by an order number ENCP E-325 stroke 5057-60 dated 20/12/2017. Transferred the petitioner from Executive Engineer E Division Twensang to under the establishment of Executive Engineer Electrical Division Kipire. No.
My lord.
No. From the establishment of Executive Engineer Electrical within bracket elect bracket close division Kipire to Executive Engineer to the establishment of Executive Engineer within bracket Electrical Division Mon. Stop. The copy of the said transfer order is stated to have issued to the Executive Engineer within bracket E Kipire as well as Mon, and also to the person concerned. Stop. The Learned Counsel for the petition submits that the said transfer order was never served to the petitioner. Was not, never served to the petitioner, nor was it received in the office of the Executive Engineer Electrical Division Kipire. Therefore, Kipire, stop. Since the copy was not made available and the petitioner was unaware about her transfer, she was performing her regular duty in the establishment of the Executive Engineer E Division Kipire. Stop. The petitioner has annexed the attendance annex the copy of the attendance register showing that she was performing her duty in the establishment of the Executive Engineer Electrical Division Kipire till the month of May 2024. Within bracket, annexure. What is this annexure? We have not marked also.
G money.
G.
G
Yeah,
money.
you have not marked. Okay, annexure G series. The petitioner.
Page 26, my lord.
The petitioner has also
G.
annexed the salary drawal register, a copy of the salary drawal register of the work charge register stroke work charge pay bill for the pay bill till pay bill in respect of the Kipire Electrical Division EE within bracket E Kipire subdivision SDO within bracket E Kipire stroke Pungro till showing that she was drawing her salary from the said division till the month of March 2024. Annexure F series. Para. However, surprisingly, the petitioner came to learn that she was learned that by an order dated by an office order number 389 number ENCP stroke E dash 314 stroke Partha PT dash Raman 2 stroke 3554 dash 57 dated 27/10/2023. C along with the 6 others were terminated from their service with effect from 20/10/2023. Stop. Para. The Land Council. It is submitted that before issuance of the said issuance of the impugned termination order dated 20/10/2023, no any notice was issued to the petitioner as required under the law. Stop. Para. After having come to know about, after having learned that by the impugned order dated 20/10/2023, she was terminated, the petitioner made a representation before the respondent number 3 through proper channel, respondent number 3. Stating
True respondent number 4.
through respondent number 4.
Yes.
through respondent number 4. Stating that after being appointed, she was working under the executive engineer Kipire. Stop, huh? And that Kipire and that although the department has issued a transfer order, the department is stated to have issued transfer order transferring her from Kipire to Mon on 2012-2017. However, no any transfer order was made available to her, enabling her to join her new posting place. Stop. The applicant also contended that the copy of the transfer order did not even reach to the establishment of the EE Kipire. Therefore, she continued working under the EE Kipire, under the establishment of the EE Kipire till date. Stop. She also enclosed. Just a minute. And therefore requested that since there has been a serious communication gap, requested for review of the termination of her service and pray for reinstatement of her service in the department. Staff. Para. The application filed by the petitioner was forwarded by the executive engineer, electrical division Kipire, to the respondent number 3, wherein the executive engineer, electrical division Kipire, within bracket respondent number 4, while forwarding her application, had made the following statement. This second para, in this regard, page 22, para 2. In this regard, it is stated that she is regularly performing so and so. Okay. Para 2 and 3. Okay. Then entire letter. Forwarded the letter. The letter, so the letter is being relevant is reproduced here and below. Entire letter. Okay. In the light of the above, in the light of the above fact and circumstances of the case, the Land Council for the petitioner prays for setting aside and quashing of the impugned transfer order dated 2012-2017, as well as the termination order dated 27-10-2023, and prays for reinstatement of his her service in the department. Stop on para. Par contra, Ms. Cheng, Land Government Advocate, while referring to the affidavit filed by the state respondent, number 1 to 5, submits. That the copy of the transfer office order number 641 dated 2012-2017, transferring the petitioner from the establishment of the executive engineer within bracket elect bracket close comma Mount Division has been duly endorsed to the petitioner. And therefore, there is no question of non-communication of the said order to the petitioner. She further submits that the copy of the impugned termination order dated 2010-2023 has also been duly endorsed to the person concerned. Hence, there is no question of non-receipt of the termination order by the petitioner. Stop. Para. The Land Government Council further submits that so that in reply to the letter of the Executive Engineer, Electrical Division, Kepire, dated 3/5/2024. The respondent number 3, why its letter dated 24/5/2024, stated that the seniority list of the department was dispatched to all the divisions every year. Are dispatched to all the divisions every year, giving 90 days time to apply for correction of data error exist, if any. However, the respondent number 3 did not receive any letter for redressing the place of posting of the petitioner featuring under MON since 2018. Stop. and despite of repeated reminders to submit monthly deposition return regularly, the electrical division KPIRA has not submitted the same. Stop. Para. See further submits that. Since the petitioner, despite of having transferred to Mon division, has never joined nor reported, she was terminated from the service for not joining the establishment of the executive engineer electrical division Mon, even after lapse of 6 years from the date of her transfer, order dated 2012-2017. Hence, no intervention of this honorable court is called for. Hard vote the Lana Council for the parties. Okay. So the conclusion I have right. Okay. But this will go automatically. This stands disposed. Okay. I'll give the order. Dictate today itself. Okay.
Much pleasure.
Our pleasure.
Yes. Three more. Is the whether these three matters are long or important? Item number 15. What is this matter about? Is a long one. Okay. What is your prayer?
As directed by this court, we have served copies of the petition to the respondent number 1, 4, 5, and 6.
Okay.
However, service of notice upon respondent 2, 3 are due to registered both ID, and we are ready to take steps.
Service upon respondent number
2 and 3.
are
2 and 3. 2, 3.
2, 3. What happened?
We are ready to take steps, Your Lordship.
Oh, you have to take steps.
Yes.
Okay, Miss.
No.
Learn counsel for the petitioner. Where is the office note? There is no office note also, it appears. Although she has taken steps upon the respondent number, you have taken step upon other respondent. Or other respondent including respondent number?
1, 6.
She has taken a step upon the respondent number 1, 4, 5, and 6. However,
For respondent number 2 and 3.
she is yet to take steps upon the respondent number 2 and 3. By 2 and 3, stop and praise for some time. Stop, prayer aloud. Steps upon the respondent number 2 and 3 by a registered post with AD as well as by usual process within a week from today. Okay, list this matter after 3 weeks. Okay. Move.
Orders, item number 16.
Yes. Still awaited, return service still awaited, it appears, upon the respondent number 2. You are for respondent number 1.
Yes.
So what to do? This was taken, when this step was taken? The 8th. So we will wait for somewhat, okay. Both, Miss Line Council, both Miss. Okay, Line Council for the petitioner and Mr. Mohammed Zami, Line Council for the respondent number 1 are present. Stop. The notice upon the respondent number 2 is still awaited in view of the above. List this matter after 2 weeks. Okay. Okay.
For hearing, item number 26.
Oh, 26 for hearing. What is this matter about? Are you ready for hearing or what?
My lord, I'm seeking Direction for appointment on land ownership basis.
Land ownership.
Yes, my lord.
And whether the respondent has filed affidavit,
Yes, my lord. Pleading has been completed, my lord.
being completed.
Yes, my lord.
This, who is for the government?
Yeah, she's
Cheng, Miss Cheng.
No, my lord. Pichano. Miss Pichano.
Pichano is not
Yes.
present, then
He's-
what to do?
she's-
We'll
she's here.
list it for hearing then. Mr. L. Lakhase, you
my
are,
lord, the advocate is the government advocate is around. I can call her if your lordship is kind enough to take up the
no,
matter.
this is what? He was earlier appointed or what?
No, my lord.
Newly,
Yes, newly, my lord.
and somebody was appointed?
No, my lord.
Then it needs hearing. Okay,
Yes, my lord.
Mr.
Elika Sesam, my lord.
L. Likhase, Land Council, Sanctum Land Council for the petitioner. No one appears on behalf of the state. Stop. It is submitted that the matter is, the pleadings are completed and the matter is ready for hearing. Stop. List this matter for hearing after 3 weeks.
Can it be after 1 week, my lord?
Okay, after 2 weeks,
Yes,
please.
yes.
Okay.
I'll bet.
I think it's finished now. Okay. This will be in that. Earlier, huh?